Hey friends, so Nate with Keyrenter Property Management here, and today I'm going to talk to you about the new Truth in Renting law. It's HB 68, which was the bill that was passed, and last month, in the month of March, it was signed into law by Governor Cox. Now it's going to be going into effect as of May 5th, and it's going to impact all of us landlords, real estate investors. If you're not the landlord, meaning you have a property management company, hopefully they know about this and will be starting to implement some practices to work with this new law. And so I'm going to share with you what that is. But before I do, I want to introduce you to one of my friends that I've gotten to know over the last several months. His name is Daniel. Let's see if you can see him here. This is Daniel with Shark Painting. And the reason I bring him up is because I know a lot of you are real estate agents. I know a lot of you are investors, landlords, flippers, whatever it is, and you might need some great painting at an affordable rate. I moved back in December to a new house. We did a ton of paint work, and he and his team were absolutely incredible. And it takes a lot for me to say that. Being in property management, we've worked with many painters over the years and a lot of different trades. And I rarely speak up about many of them simply because, I have to have personal experience with them, right? And in my own home, they did such a fantastic job. And so he's not paying me to say this. I just feel like I want to give you the benefit of having a great resource and someone on your team to help with your painting needs that you might have. He did a lot of interior work. He did a lot of exterior work, a ton of different things that he was able to do at an affordable rate. So his contact information will be in the email or pop up on the video, however you're watching this. So back to HB 68 and what that means. Okay, so what this bill was and what the law is now, Truth in Renting, essentially it requires landlords, when we're leasing a property, we're advertising it for rent, that we need to disclose the fixed fees, so rent or any other recurring fees that a tenant would have to pay in the advertising. And it can be in the advertising as well as in the application disclosure section. I'm going to have more clarification. We have a government affairs committee next week where we're going to be diving in here and getting some real tangible things that you can implement, and I'll share with you a little bit more, as well as some of the other bills that were put forward. And so more of that to come next week. But with this, so if the rent or the utilities are fixed or any other sort of monthly fees, you need to put that in your advertising. It's just really simple to line item that in there. And what this law is about is to protect tenants from getting into a situation where they kind of feel like there's this bait and switch, like we're trying to slide a hand and entice a tenant to apply, but then when we give them the lease, it's a different rate or there's additional fees. It's just kind of, in my opinion, it's kind of shady business. We've been disclosing all of the fees, everything up front for years, so it's not really going to impact our business much. But there are quite a few landlords who will do this. And what happens is the tenant pays the $25, $40, $50, $100 application fee, and they can't get it refunded because, it's non-refundable. You applied. If you don't want the lease, take it or leave it. And it's just something that's been put in place to protect tenants, something that I've actually, supported to some extent. Now, it has been modified. We've worked with the UAA and various groups to really work to make this an agreeable law and a solution to really help people out. What would happen if you don't disclose the application or in the ad, the recurring fees, is if that tenant is presented with the lease and it's different, they can request within 5 days, that is the provision, they have to do it within 5 days of having been given that lease, they have to request a refund. And they just have to dispute it at that point. So they request from the landlord a refund of their application fees or any fees that they've paid at that point, and they can get those refunded back. And there is recourse if the landlord does not provide a refund. So that's what it is. And so you guys, as you're looking at your your advertising, I just really encourage you to make sure that they match what you're stating on the lease so that you don't have this sort of issue. I feel like it's just good business to do that, and it's good customer service. You don't want to have a tenant expecting one thing and they go to sign the lease and it's completely different. So that's important. So again, more to come on that. And I hope this is helpful for you guys. Have a great and awesome day and week. See ya.